Good morning, everybody. Thanks, Roger, for the introduction. The human right to health is at the early stages of its intellectual and operational journey, and I've been invited this morning to introduce you to some features of this journey and to make some links to development. My vantage point is not one of a philosopher or a political theorist or health professional, but a human rights lawyer who has worked within the UN human rights system. A brief word on terminology. I use the term the right to health as a shorthand for the right to the highest attainable standard of health, or more accurately, the right of everyone to the enjoyment of the highest attainable standard of physical and mental health, as set out in Article 12 of the International Covenant on Economic, Social and Cultural Rights. And as you know, this treaty is legally binding on the more than 160 ratifying states parties. Of course, as we know, international accountability in relation to the right to health is weak, consisting mainly of the Human Rights Council's Universal Periodic Review, also independent treaty bodies and independent special rapporteurs. There are some important but lesser known international accountability mechanisms that also encompass the right to health, such as the UN Secretary General's new independent accountability panel for women's and children's health. Public international law is characterized by weak accountability arrangements, and international human rights are part of public international law, and they cannot escape public international law's systemic limitations. I said at the beginning that I'm going to comment on the right to health. I referred to the right to health as being at the early stages of its intellectual and operational journey. And I want to very briefly explain what I mean by early stages. The right to health emerged at the international level in 1946, and for a few heady years it was energetically championed by the WHO's first Director General, Brock Chisholm. Chisholm's term ended in 1953. His successor had no time for the right to health, even though it is in the organization's constitution, and that was pretty much the end of the right to health in WHO. That is, until recent years, when there has been a limited revival within the organization. If you're interested, by the way, in the history of WHO and the right to health, I strongly recommend the scholarship of Benjamin Meyer. The first conference, or workshop actually, the first workshop on the right to health was not held until 1978. Its proceedings, published in 1979, are the first volume we have on the right to health. The first single author book on the international right to health, a pioneering doctoral study by Birgit Tobes, was published 20 years later in 1999. Since 1999 and 2000, there has been a steady stream of academic books, articles, reports, and other publications on health and human rights, including the right to health. So, although the international right to health emerged in 1946, it has only received sustained scholarly attention in the last 16 years. That's why I suggest these are early days for the right to health. And it seems premature to me to talk about the twilight of human rights, when, in relation to economic, social, cultural rights, dawn has only just broken and we are barely out of bed. Today, I'd like to briefly review what progress has been made in relation to the right to health. I want to suggest that the right to health still struggles to gain traction in many governments, and I want to briefly explore why that is the case. So first of all, beginning with some progress. First, progress in terms of the scholarship. As I've already observed, there is now a steady stream of scholarly literature on the right to health. human rights and health rights, similar formulations. This literature often clusters around a handful of topics: medicines, sexual reproductive health, poverty and neglected diseases, philosophical foundations. Other topics include mental health, women's and children's health, litigation, international assistance and cooperation, and huge generic topics like healthcare, public health, and global health. But what's the progress, if any? What are the developments in the classic UN human rights system in relation to the right to health? Well, since 1999, the UN human rights system has produced several substantive, normative elaborations of the right to health or closely related topics. These include the Women's Rights Committee's General Recommendation, adopted in 1999, the Committee on Economic, Social, Cultural Rights General Comment, adopted in 2000, the Child's Rights Committee's comment in 2015. There are others. For example, just a few months ago, the Committee on Economic, Social, Cultural Rights adopted a general comment on sexual and reproductive health. Since 2003, 3 UN rapporteurs on the right to health have written more than 50 right to health reports and orally presented them to the General Assembly, Human Rights Council, or the old Commission on Human Rights. Most are on generic right to health themes. Following country visits at the invitation of the relevant governments, country reports look critically at the right to health in specific countries, often informed by the work of civil society organizations. Some reports look at non-state actors, such as the World Trade Organization, World Bank, and the pharmaceutical company GlaxoSmithKline. Many thematic and country reports look at development issues and the right to health. For example, this week, the current rapporteur, Ferraz, is presenting his report on the Sustainable Development Goals to the General Assembly. Health rapporteurs also receive numerous right to health complaints from the public, and they take up some of these with relevant governments. Rapporteurs summarize these complaints in their UN communications reports, communications being UN speak for complaints. Note the relationship between general comments that I mentioned a couple of minutes ago and rapporteurs' reports. Often rapporteurs take the general comments and apply them to a specific theme or to a specific country. And in applying the general comments, the rapporteurs often have to develop and refine them. And may I very briefly add a personal reflection about the elaboration of these general comments. I used to sit on the independent UN Committee on Economic, Social, Cultural Rights, and when drafting a general comment on a specific right, the right to food, education, health, and so on, it felt like the Covenant provided a very bare framework on which we had to build an edifice. The edifice, that is a more detailed understanding of specific rights. The edifice was needed because otherwise it was very difficult to hold anyone accountable for anything. The bare framework was provided by the Covenant's Articles of General Application, non-discrimination, equal treatment, Articles 1 through to 5 of the Covenant. And also, the framework was also constituted the articles relevant to the specific right in question. For instance, the right to health, Article 12, the right to education, Articles 13 and 14, and so forth. So there we have a bare framework, but how to build an edifice on this bare structure? And we were guided by the interpretive principles set out in the Vienna Convention on the Law of Treaties, especially Article 31, which requires that treaties be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty in their context, and in the light of its objects and purposes. Broadly speaking, there are 3 schools of thought for treaty interpretation, and all 3 can be discerned in Article 31. And we leant towards a teleological interpretive approach. We would also consider the relevant right to health provisions of more recent treaties, for instance, Article 24 of the Convention on the Rights of the Child, which post-dated the Covenant by some decades. However, at least in the early days of the committee, when trying to build an edifice on this spare framework, it felt like we did not have all the necessary conceptual bricks. To give one example, The right to health is subject to progressive realisation. But what does progressive realisation mean, and how do you measure it? It might seem bizarre now, but in the 1990s, there was resistance to using indicators to measure the progressive realisation of human rights. It was for this reason that in the noughties, when serving as health rapporteur, I devoted 3 UN reports, informed by numerous consultations, on the role of indicators and benchmarks in measuring the progressive realisation of the right to health. And those 3 reports built on the committee's general comment on the right to health. In my 3rd report, 2006, I suggested we should use structural, process and outcome indicators. Now, thanks to Sakiko and many others, we have a much more sophisticated understanding of the role of indicators in relation to human rights. Today, the indicators benchmarks conceptual brick is by no means settled, but reasonably well formed and reasonably well established. My point is that when wrestling with the normative elaboration of the right to health and other economic, social, cultural rights, it felt like we were not only required to build an edifice around a bare structure, but we were also required, supported by many others, to design and make the conceptual bricks with which to construct the building. Unquestionably, the framework, the conceptual bricks, and edifice can and should be refurbished in the light of experience and fresh thinking, and I hope this seminar will make a contribution to this end. But to go back to progress, what about right to health developments within UN agencies? In relation to the right to health, there is a trend to move from the general to the specific, to move from the abstract to the operational. And this trend is very clear in the human rights work of UN agencies. UN agencies have adopted increasingly detailed guidance on how to operationalize human rights. For example, in relation to HIV/AIDS, 2006. In relation to maternal mortality, guidance of 2012. Guidance in relation to under-5 mortality, 2014. Guidance in relation to contraceptive information and services, also 2014. And this year, guidance on clinical management of female genital mutilation, all of these drafted in the context of human rights, including the right to health. If you are a health policy maker or practitioner, treaties and general comments provide you with limited guidance. You need something more specific, something more practical, and that is what the agency's human rights technical guidance aimed to provide. Practical human rights guidance of this sort cannot be written by lawyers. They require a multidisciplinary authorship. They not only have to weigh the relevant norms, they have to weigh the relevant evidence. For example, the International Covenant on Economic, Social, Cultural Rights places an obligation on governments to take all reasonable measures towards the reduction of maternal mortality. When trying to calibrate what are reasonable measures in a particular national or provincial context, one has to know the evidence on the efficacy of different health interventions. Thank heavens the global health community can now advise us on evidence-based priority health interventions for the reduction of maternal mortality. I say thank heavens because we had to wait for some time for this global advice. So, for example, one such evidence-based priority health intervention for the reduction of maternal mortality is family planning. So human rights guidance on the reduction of maternal mortality requires a multidisciplinary marriage of norms and evidence. For example, good quality family planning must be available on an equitable basis without either discrimination or without spousal approval. Policymakers and practitioners can then use such guidance to design human rights-shaped interventions for the reduction of maternal mortality, including family planning. Also, policymakers and practitioners can be held accountable for their interventions, not with a view to blame, sanction and punishment, but with a view to identifying what works so it can be repeated and what doesn't work so it can be revised. They can also be held to account if, say, family planning is altogether absent, or if it's only available in urban centres, or if it's only available with spousal consent. WHO, the Office of the High Commissioner for Human Rights, UNAIDS, and other UN bodies and agencies have under-resourced teams whose job it is to promote these various human rights guidance for HIV, maternal mortality, under 5 mortality, and so on, to promote those guidance among states, including their ministries of health. In my view, the quality of the various human rights guidance provided by UN agencies is uneven. They need more work. Also, we need more research on the degree to which states and others are actually using the guidance and to what effect. But nonetheless, in my view, this new wave of UN human rights operational guidance is a very welcome and very important development in the right direction. And this guidance, recently developed, is gradually deepening our understanding of the content of the right to health, although, of course, there's still a long way to go. What about progress in constitutions and courts? Suffice to say, there are now a large number of constitutions and other national laws which include the right to health and similar formulations. In some countries, these laws are generating a huge amount of case law before the courts. Octavio, who's on the panel here with me, has critically interrogated some of this jurisprudence and its impact, and we are indebted to him for this research. In brief, there is evidence that some of the case law favors the middle class and disadvantages those living in poverty. Time is very short, and so I confine myself to 3 brief points. First, in many right to health cases, courts will not be able to do their job properly if they are not provided with what the jargon calls health technology assessments. These assessments provide evidence on the clinical effectiveness, safety, cost effectiveness, and social, ethical, and legal implications of the relevant medicine or other intervention, which is the subject of the litigation. Health technology assessments are crucial. Second, the right to health has to be balanced with other human rights and other human rights principles, including non-discrimination, equality, and the rebuttable presumption of non-retrogression. Striking principled balances can be very difficult, but judges are constantly striking difficult balances in the context of civil and political rights, for example, in relation to freedom of speech and privacy, freedom of speech and incitement to racial hatred, and so on. And they can also strike difficult balances in right to health cases, provided they are assisted by the provision of robust health technology assessments. Third, the right to health gives rise to obligations and calls for accountability. But judicial accountability is only one form of accountability. There are other forms of accountability, such as local and national legislatures, for instance, select committees, national human rights institutions, and civil society organizations. Judicial accountability is important, but it's accountability of last resort. I will make another short remark in a moment about health rights litigation. But now, briefly, national human rights institutions. Have they made progressively a contribution or addressed the right to health? In some countries, some national human rights institutions are now giving serious attention to the right to health, and I'll just give 2 short examples. In 2012, the Kenya National Commission on Human Rights published a report called Realising Sexual and Reproductive Health Rights in Kenya. The report was the fruit of an 18-month public inquiry. The inquiry took evidence in public across Kenya. Closer to home, the Northern Ireland Human Rights Commission recently held a public inquiry on emergency care. The exercise took about 1 year. We received written evidence and also heard oral evidence at a number of public hearings. Our report was published last year. Both these public inquiries, and there are others, both public inquiries provide recommendations and were exercises in human rights accountability, specifically in relation to the right to health. And what about civil society? Has there been progress there? Today, very many NGOs are working on health rights, from Amnesty International and Human Rights Watch through to a myriad of grassroots organizations. Frankly, I cannot cite hard data. Perhaps others in the room can. But my impression is that the number of NGOs working on economic, social, cultural rights generally, and the right to health specifically, has grown dramatically in recent years. But crucially, what about states? What's the profile of the right to health amongst states. On the positive side, there is evidence that some states, for instance Nepal, Brazil, Malawi, Italy, are explicitly using the right to health to shape their policies. And there is also some evidence that these human rights-shaped interventions are contributing to, notice I don't say causing, these human rights-shaped interventions are contributing to health gains for individuals, communities and populations. See, for example, the WHO monograph, Women's and Children's Health, Evidence of Impact of Human Rights, published in 2013. And see also the recent special issue of Harvard's Health and Human Rights Journal on Evidence of Impact of Human Rights, published in 2015. Some right to health litigation has had a significant impact in some countries, such as systemic reform of the health system in Colombia and improving access to antiretrovirals in South Africa. There is also anecdotal evidence that following some rapporteur country visits and reports, the right to health enjoys greater currency and becomes part of some health policy making. I won't go on, time is too short. Of course, this is only a cursory, incomplete survey in relation to states and the right to health. But I have to say that, in my experience, overall, the right to health is acquiring limited traction in most governments. In most ministries of health, the right to health is not explicitly shaping policies and programs. In most national communities of health professionals, the right to health has a low profile. If I'm correct about that, why is this? Since the turn of the century, there has been a dramatic increase in literature reports, guidance, court cases, and so forth on the right to health. If that is correct, why is there not more governmental action using the explicit language of the right to health? In other words, why is the promotion of the right to health among ministries of health such hard work? What are the possible explanations? There are many. It's complicated, but briefly I mention four. The first candidate explanation, that there is not yet a compelling account, foundation, or justification for the right to health. That's one possible explanation. I've got two problems with that as a candidate explanation. One problem I have is that I'm not sure that it's true. It seems to me that we now have a number of reasonably coherent accounts for the right to health based on dignity, social interest, capabilities, and so on. And like Sakiko this morning, I find the latter, capabilities, especially compelling, based on Sen, Nussbaum, Ruger, Ram, Ticktin, and Venkatapuram, one of our colleagues on the panel this morning. The second problem I have with this putative explanation is that I've never discussed the right to health with a health policy maker or a health practitioner who has objected to it on the grounds that the right to health is philosophically incoherent. Of course, I accept that much more work is needed on the ethical foundations of the right to health, but I'm not yet persuaded that the further advancement of the right to health depends upon this work being done. A second candidate explanation as to why the promotion of the right to health in ministries of health is such hard work. Well, the second candidate is that there is not yet a consensus on the content of the right to health. I accept there is not yet a consensus on the content of the right to health, and I think that more work is needed on content and scope of the right to health. But when approaching the content of the right to health, or the content of any human right, I do not think that consensus is the correct approach for a number of reasons. One, it will drive us to the lowest common denominator. Two, a consensus approach does not sit comfortably with the claims of minorities who are a particular preoccupation of human rights. Three, a consensus approach favors those with voice, space, agency, authority, and power. Economic, social, and cultural rights have a special importance for those living in poverty. Those living in poverty do not have voice, space, agency, authority, and power. Thus, a consensus approach will reflect and further entrench the disadvantage of those living in poverty. Of course, the content of the right to health must be clear, credible, coherent, realistic, feasible, and it must have a measure of legitimacy, but I doubt by way of consensus. I tend to favor a consensus on essential principles and on a right to health framework, and then the appointment of a diverse and accountable group of independent people to develop the content of the right to health, crucially by way of a dynamic process that includes the active, informed, and meaningful participation of those living in poverty. As an aside, Tobin devotes a chapter to a methodology for the interpretation of the right to health by way of an interpretive community, but without even mentioning those living in poverty. A third candidate to explain why promoting the right to health in governments is like stirring treacle. The third candidate is this: the prevailing economic orthodoxy is neoliberalism, and the enjoyment of economic and social cultural rights is incompatible with this orthodoxy. This discussion we began earlier today. Paul O'Connell and others take this position, and I find it increasingly compelling. The values informing the right to health include equality, non-discrimination, equity, participation, transparency, accountability, empowerment, solidarity, and the dignity and well-being of all individuals, communities, and populations. These values, as often used in the human rights discourse, do not resonate with those values driving neoliberalism. As I understand it, there is evidence that neoliberalism has helped to lift many people out of poverty. But there is also evidence that neoliberalism has impoverished many, left many communities behind, and widened inequalities. I suggest that the influence of neoliberalism is not the only reason, but one of the reasons why so many governments are resistant to economic, social, cultural rights, including the right to health. However, even if I am correct about that, this must not be used as an excuse not to advance the right to health as best we can. For example, greater clarity is needed about the content and scope of the right to health. We must devise ways to operationalize the right to health and, so far as possible, make the right meaningful for all, including those living in poverty. The fourth possible candidate explanation for why the right to health finds it difficult to make headway in many ministries of health, the fourth candidate is this. At root, human rights are a normative enterprise, whereas health professionals are trained to esteem evidence. Health professionals want evidence that an intervention saves lives or reduces suffering. Health professionals, in my experience, are more likely to be persuaded by evidence than norms. Yet the human rights community has been slow to marshal evidence of impact of human rights, a shortcoming that is now being slowly addressed in some quarters. Of course, this is a complex endeavor looking at evidence of impact, raising important issues of epistemology and also causation, attribution. But if we wish health professionals to take human rights seriously, I suggest we need to deploy normative arguments supplemented by evidential arguments. Let me now draw to my conclusion. I'd like to conclude with some short comments. Firstly, very briefly about big data, and secondly, about development. Firstly, briefly, big data. These days we hear a great deal about big data. Big data presents risks to human rights, such as risks to our right to privacy. But perhaps big data also presents opportunities for human rights. For example, perhaps we can use big data to measure the progressive realization of the right to health, and in this way better hold duty bearers accountable. My second and last point in my topic, in my conclusion, concerns a few remarks on development, which we've already learned about from Sukiko this morning. If one conceives of development as sustainable development, there is a complementarity between it and human rights, including the right to health. This complementarity is evidenced from the scholarship of Amartya Sen, which also informed the important UNDP report of 2000 called Human Rights and Human Development. The UN reports of Arjun Sengupta also advanced our understanding of development and human rights, including the right to health. I also find very instructive some of the work of the Human Rights Council's high-level task force on the implementation of the right to development, on which I think Sakiko honourably served. I especially recommend its report of March 2010, with its core norm, its 3 attributes, criteria, sub-criteria, and indicators. Yes, I know the language is ghastly, but take a look at that report of March 2010. Persevere, because the content is first-rate. The report helps to clarify what the right to development means and how it can be implemented, and it identifies 3 layers of duty bearers. And in that report, health recurs throughout. This report has nuanced analysis and prescriptions which bear upon development, human rights, and health, and which deserve our attention. If I had to choose one feature of human rights, including the right to health, that would contribute most to sustainable development, it would be the sense of legal obligation from which accountability arises. And by accountability, I do not mean only monitoring, but independent review of developmental and health commitments, backed up by remedial action. My final short remark is this. Earlier this month, I saw a play called Carry On, Jaywick. Jaywick is a small town on the east coast of Essex, about 10 miles from where I live. It's often cited as being one of the most deprived communities in the United Kingdom. The play, which I recommend, is made up entirely of the original edited recordings of the citizens of Jaywick. There is also a serious documentary called Jaywick Escapes, and a less serious, sensationalist reality television program about Jaywick called Benefits by the Sea, which some of you might have seen. I won't burden you with the data, but in short, Jaywick is an archetypal, left-behind community, but with spirit, with elan. In my view, Jaywick and other left-behind communities in the United Kingdom would benefit from a human rights-based approach to development, encompassing work, food, shelter, participation, a cultural life, agency, empowerment, accountability, and health. Thank you very much.
Thank you everyone for coming. Thank you, John, for inviting me to take part in this great event. Thank you, Roger, for the introduction, and thank you, Paul, for your paper. I have 10 minutes to comment on it. I haven't received the full paper in advance, but we did exchange quite a few emails during the week, so I had an idea about what Paul was going to speak. So mine was also pre-prepared, but I think it works really well. My first academic post after 10 years of legal practice, during which I managed just to also complete a PhD on social and economic human rights, was as research assistant to Paul Hunt in his then capacity of UN Rapporteur on the right to health. Although it was just a brief period of 7 months, and Paul was rather busy trying to stop the American government from breaching the right to health of detainees in Guantanamo Bay, I remember that time fondly as the beginning of my now 10-year-old interest in researching the right to health. I also remember vividly when Paul asked me what, in my view, should be the focus of his next report for the UN General Assembly in the capacity of UN Special Rapporteur. My answer was that it should be a discussion of the concept of maximum available resources, which qualifies states' duties to guarantee social and economic rights in the International Covenant, Article 2.1.
Octavio is still waiting for that one, I'm afraid.
My view then, and is still my view now, is that this is an intractable but crucial task if social rights in general and the right to health in particular are to have teeth. It also fits perfectly with the topic of this conference on human rights and development and relates to the question Poe posed about the reasons why the right to health, but also other social and economic rights, seem to have such a low profile or seem to lack teeth. Well, by having teeth, I mean being capable of providing a reasonably clear standard against which governments can be measured and criticized, which I take to be one of the main functions of the international human rights system. We can call this accountability, as Poe has mentioned a lot in his talk. But let me haste to add a couple of clarifications here to avoid misunderstandings about my position. I do not think that judicial enforcement, often called justiciability, is an essential part of accountability, nor that it is the ideal or the strongest form of accountability. And I think we agree on that, as I just heard. Despite my past as a litigating lawyer for almost 10 years, or perhaps because of this, I think that justiciability is only one among many potential forms of accountability, and that its strength may vary significantly according to context. In some cases, as I tried to show in some of my writings on the judicialization of the right to health in Brazil, justiciability might actually have negative consequences in the protection of rights. So my point here does not presuppose any particular form of accountability. What it does insist on is that human rights standards possess a reasonable degree of clarity so as some form of accountability, whatever it is, can be meaningfully exercised. Naming and shaming, diplomatic pressure, UN resolutions and reports, and also even adjudication when appropriate. Now, I must haste to add another important clarification to avoid another potential misunderstanding. I do not think either that lack of clarity, that is, indeterminacy or vagueness, is an exclusive attribute of social and economic rights. Civil and political rights can be, and often are, also subject to indeterminacy. And this applies not only to the positive and costly duties that they also give rise to, but also to the negative ones. To cite a couple of examples, what threshold of severity distinguishes torture, inhuman and degrading treatment, and legitimate punishment? Should all prisoners have the right to vote, independent of the gravity of their crimes? I do believe, though, that the nature of indeterminacy varies according to the rights and duties at stake. So indeterminacy on torture, voting rights, health, and education are not all the same. And that this may have an effect on the degree of indeterminacy and the difficulties of overcoming it. Indeterminacy about maximum available resources may be more difficult to overcome, more on this later, than indeterminacy about torture, for instance. But my argument does not rest on what turns out to be the answer to this empirical question. Any right, be it civil, political, social, and economical, will suffer from lack of teeth, that is, from an accountability deficit, to the extent of the indeterminacy of its content. Now, having made these clarifications, I would like now to go back to the maximum available resources quandary. To be able to hold a state accountable for not respecting the right to health or any other social, civil, or political rights corresponding positive duties, we need to know if the state is using its maximum available resources. But how can we know that? If it is impossible to know with a reasonable degree of certainty, then we must resign ourselves, or at least those who support social rights, like us, that they are helplessly indeterminate and, as a consequence, lacking in an important element we tend to associate with the idea of rights: accountability. Whether they can still be called rights or real rights, genuine rights, from the perspective of conceptual truth, is, in my view, not the most important matter. The most important matter is that acute indeterminacy faithfully affects the ability of a right to fulfill its paramount function. That is, to enable some form of accountability against states who fail to implement them. Note that the problem here is not the lack of effectiveness of enforcement mechanisms. Another general problem affecting both international and domestic law in general. Poe has referred to that as systemic weakness of the international system. I think we'll hear more about that from Eric Posner at the end of the day, perhaps. The problem here is deeper. Indeterminacy prevents us from knowing what ought to be enforced in the first place. Right to health supporters must therefore give priority to the solution of what we could call the indeterminacy problem. And this involves tackling the intractable yet crucial question of what maximum available resources mean. This question is not, of course, a purely empirical question of how much resources exist in the world or within countries. It is also a normative question about how these resources ought to be distributed and how much ought to be devoted to the fulfillment of the right to health. The intractability of the problem is readily apparent, as it involves answering a set of further complex and controversial questions pertaining to the fields of distributive justice and social policy. To cite just a couple of main ones, what should be the geographical scope of our inquiry, global or national? Different countries in the world vary enormously in terms of economic development. Should we look at the available resources within countries or in the world as a whole when discussing available resources for the human and therefore universal right to health? Whatever the answer here, a further set of questions need to be tackled. Again, let me mention just a few for the sake of time. How much resources should be available to states vis-à-vis civil society? That is, how much of the aggregate wealth in existence should a state appropriate through taxation, and how much should be left in private hands? Once a certain taxation level is set and the state collects revenue, how much ought to be devoted to health in light of all other revenue-dependent duties the state has, both rights corresponding duties like education, housing, security, and non-rights corresponding duties like arts, leisure, sports, etc. Once the health budget is fixed, how much should be devoted to each of the myriad health needs of the population? Once the so-called meso-allocation decisions are taken about which needs should be receive resources, how should the resources devoted to each meso area be distributed among competing needy individuals? So even this overly simplified scenario is sufficient, I think, to scare anyone attempting to risk a substantive answer to the question of what maximum available resources mean. It also explains, in my view, why so many have come to the conclusion that we ought to focus on the fairness of the decision-making procedures for answering those questions and not on their substantive outcomes. Norman Daniels came straight to mind. Yet, I emphasize, if this is all that the right to health is a right to, a right that imposes a duty on states to decide how to allocate its available resources in a fair manner, with no reasonable, clear, substantive constraints on how much resources health ought to receive and how these resources should be distributed, then the accountability element of that right is not very strong. Its teeth are not very sharp. Perhaps this is all we can hope for, to paraphrase one of the prominent speakers of the afternoon. Perhaps the right to health and all other social rights or positive duties corresponding to civil and political rights are more like indeterminate goals to be pursued with some degree of priority, strong social commitments in Amartya Sen's formulation. And as he rightly puts it, this is not so little. Some of the most developed public health systems in the world were built on such indeterminate goals. I think Fukuda Parr referred to some of that in her speech as well. But we may perhaps aim higher, and by that I conclude. And this would be particularly important in countries where such strong social commitments cannot be taken for granted. One potential route, of which we will hear much more later on, is the so-called minimum core approach. I think it goes in the right direction in trying to establish minimum entitlements that can be immediately claimable, that have teeth. But I have not seen yet a clear proposal on how the minimum core can be specified. I also disagree with how it is usually presented as a subset of the full right, as in my view, this creates an artificial and implausible distinction between core and non-core rights. So to finish, a more promising way forward, in my view, would be to strengthen the procedural conditions of a fair allocation of resources with some minimum substantive content grounded on the idea of equity. This would serve as a trump against certain allocative decisions which are clearly inequitable, such as funding highly expensive interventions for non-serious conditions that affect mostly the better off, while not funding extremely cheap health interventions for very serious conditions that affect mostly the poor. The literature on the just distribution of health resources has been developing principles and discussing many concrete examples of such unjustified decisions. They sometimes call it unacceptable trade-offs. We lawyers, and I think we agree on that, need to engage much more with this scholarship in our attempt to specify the content of the right to health. So such decisions, I think, can be plausibly criticized as a breach of the duty to use maximum available resources, so as everyone can enjoy the right to health. Now, this proposal, and I finish, which needs much more elaboration, and I cannot give it here for obvious reasons, provides some teeth, that is, some accountability to the right to health, and could be extended, in my view, to other social rights as well. There will remain many cases, of course, in which no clear answer will be available. But this is in the nature of the rights enterprise, be they social and economical or civil and political. Thank you.
Well, thanks very much to our speakers for, well, first of all, to Paul for that panoramic view of progress and the plea, I think, to keep on pushing, and to Octavio for those, particular proposal there. So the floor is open for comments and questions. Can I follow Honora's example and just, well, we already have, I'm going to go to the right, to the very far back, and then to the gentleman in the red jumper, okay?
Thank you very much. Siobhan McInerney from the World Bank. Thank you, Paul. Thank you, Octavio. I listened carefully, Paul, to the four explanations, possible explanations you gave for resistance to the right to health among government officials. They sounded really familiar to me, and I think you know the question that's coming. If you were confronted with a development practitioner asking you why human rights, what, in your view, after all these years of work in this area, as well as on the specific interface of human rights and development, what, in your view, is the strongest articulation of value added, leaving aside for a moment how controversial it is to be looking for instrumental arguments? So how would you answer the question of what is the value added? Thank you.
Do you want to answer that now, or do you want to get another question? Another question? Yeah. We'll have the gentleman in the red as well, so just hold that question for a minute while Paul's thinking about the answer.
Thank you for your talks. I had a question for Professor Hunt. Given what you said, do you think that the most effective way to further the right to health is to combat neoclassic economic theories?
Could you repeat that for me, please?
Do you think that the best way to further the right to health in the world is to fight against neoliberal economic theories?
The second question first. The answer is yes. I think contemporary understandings of economic neoliberalism have to be contested, and I think we now have sufficient evidence, as I indicated earlier. We have sufficient evidence that economic neoliberalism that has prevailed in the last 3 decades or so has immiserized, impoverished significant numbers of vulnerable communities and widened inequalities and deepened poverty in some quarters, not in all, in some quarters. And my view at this point, my mind remains open, is that that we need a different economic model. If we remain with the present understanding of economic neoliberalism, we are not going to get the enjoyment of economic, social, cultural rights for all. Have I answered your question? I'd like to know what your view is. Can I go to Siobhan's question? Yeah, I mean, thanks for nothing, Siobhan. Such a difficult question. No, seriously, thank you for the question. It's a really important one. And after all these years, I should have a crisp answer to it. The way, I don't think it's crisp, but my response to it in no particular order is that the law requires human rights to be taken into account. So as a lawyer, it's a legal requirement. A legal policy, policy has to conform to environmental standards. It has to conform to, in local government, to planning standards. It has to conform to tax requirements. A policy has to conform to human rights standards. Even if the mechanisms of accountability at the international level and the international level and national level are weak, it's still the law. And it doesn't cease to be the law because accountability mechanisms are feeble. So the lawyer's answer is, it's the law. You've got to comply with it. The second point would be that I think there's increasing evidence, but still too little, that taking on a human rights-based approach furthers human flourishing. In the context of the right to health, that taking on a human rights-based approach reduces human suffering, that it has positive health gains for individuals, communities, and populations. There's now some evidence to that. So if you wish to be if you are a developmental, a professional working in development, and you want to know how to enhance development, you look to the evidence, and part of the evidence suggests integrate human rights. Now, I accept the evidence is still much thinner than I would wish. I don't think that is because there are not positive gains arising from a human rights-based approach to development. I think that part of the reason why we have so little evidence is that we haven't been asking those questions. We, the human rights community, has been looking, mainly resting upon normative arguments. And I think that we need the normative arguments, but we also need the evidential arguments if we're interested in multidisciplinary collaboration. Now, this is relatively new because for years, lawyers had a stranglehold, frankly, on human rights. But now, operationalization of economic, social, cultural rights means we have to have on board health professionals, economists, and so forth and so on. And if we're going to engage with those other disciplines, we have to have evidence that will help to persuade them. So the second, not uncrisp, the second uncrisp answer to your question is that there is now some incipient evidence of impact that taking on a human rights-based approach contributes to human flourishing. The third thing is not quite the same as the first two, but there's a moral requirement to engage in human rights. So putting aside law, putting aside evidential impact, there's an ethical imperative which finds expression in human rights law to engage in a human rights-based approach. So, Siobhan, it's a pleasure to see you here again. And And that is a not terribly satisfactory answer to your very pertinent question.
Down here, just halfway down, and then across.
Hi, thanks. I'm Adam Ettinson. I'm coming from the University of St. Andrews. I was intrigued by this comment you made about the need to combine normative reasoning with empirical evidence. So I just wanted to ask you to elaborate on that a little bit. So you talked about big data. I'm not sure what that is, but I was curious what's in the back of your mind when you use the example. Are you thinking about randomized control trials here that would measure the effectiveness of different health-based interventions? Are we supposed to use this data to think about what it's possible for states to do, what it's reasonable to expect states to do, or what the most effective interventions would be? I just wanted to sort of get an example in my mind so that I could, use that to sort of think a little bit more about what you're suggesting.
Do you want to get the other questions? Another one? Yeah, we'll have the other question as well, if we may. Big data could consume a lot of time, but let's have this question as well, if we may, yeah.
Okay, my question is for Octavio, so should I ask it, or yes? Okay, so I was very interested in your discussion of maximum available resources, which I've puzzled about also. And it seems to me that, as you mentioned, there's a certain amount of wealth in a country, and a certain portion of it the government will be able to extract in order to spend in whatever way. And I think the instinct of, let's say, these policy analysts who don't pay much attention to human rights would be the government should just spend this money in whatever way produces the maximum amount of well-being for people. So, and we look at the marginal dollar. So the marginal dollar, maybe it should be spent on health, but maybe it should be spent on public art, or for cleaning up litter, or for repairing street signs. There are a whole number of things that the government might optimally do with that money. And the thing about that is that it's not clear to me that you need once you're thinking in that way, that you need a right to health anymore. You just tell governments, encourage governments to spend the money in the way that will maximize the well-being of people, which of course health is an important part of their well-being. But it seems to me once you take that idea of resources seriously, what is left of the right to health? And what you hinted at was that there's some more minimal notion of health that's left over, but it would be great if you would expand on that.
Okay, I'll go first. Thank you for that question. I think we have to distinguish, in the much more elaborated version of this, I distinguish between several levels of resource allocation. The first one you mentioned, how much tax the state can collect from society. I'd call it macro level. And then there are the meso and the micro level, so it goes down and it becomes more and more specific. I agree that at the macro level, it's very difficult to establish any criteria. Well, how much should the tax burden in a country be? If it is zero, one of the examples you gave, I think it's clearly incompatible with any rights, because you will not be able to do anything unless the neoliberal magic has worked so well that everyone is well off. But in normal circumstances, you need a reasonable degree of tax revenue to be able to do things. So, but this is impossible, I think, to determine what is the correct level. But once you've done that, say you've devoted 4% of the GDP to health, which is the case of Brazil, where I come from, right? Then within that budget, I think there are some decisions that would go against the right to health. And I gave one example, and it's one example which actually doesn't come from my fanciful dreams, but it's a reality in many countries. You invest a lot in some very expensive equipment or drugs that might add a couple of weeks, if that, to the lives of well-off individuals who are already advantaged in terms of health, and 50% of the population lack basic sanitation, right? I think there you could make a strong claim that the right to health is being disrespected. So, on the general, when you focus only on well-being, you are thinking about the whole health, education, housing, all the policies. But most countries divide their budgets into health, education, housing, and then once that is done, I think there is a degree of control, of accountability that human rights can bring to the meso and micro decisions that will be taken. I hope it's kind of an explanation.
Thanks for your question, and I'll make a few remarks, but do take a look at the special issue, December 2015, of the Harvard Health and Human Rights Journal, which looks at these tricky issues around evidence of impact of human rights on health. This is quite a new field, and we don't have. I don't mean the right to health is a new field. That is too, in historical terms. But I mean the question of evidence of impact of human rights is quite new, and much more work needs to be done to clarify issues of method and evidence and causation. But to try and answer your question specifically, in one study, we looked at some countries and we asked two questions. We said, the first question was, is there evidence that human rights have explicitly shaped certain, not all, certain health policies? So that's the first question. Is there any evidence that human rights have explicitly shaped certain policies? So that requires us looking at the laws, policies, the wording of ministerial statements. It requires looking at implementation programs. It requires digging down quite deeply into policies, plans, and programs. And in some cases we found, well, there was reasonable evidence that human rights had shaped this stuff. There was a minister saying that he or she was going to do it. And then when you unpack the implementation plans, there were human rights explicitly, and their concepts were there too. So that was the first question. Have human rights explicitly shaped certain policies? And then the second question is much harder. Is there any evidence that those explicitly human rights shaped interventions have contributed to health gains? And that's difficult. So you talked about randomized control trials. We formed the view that the test of causation could not be probabilities and randomized control trials. We thought that was inappropriate. But we also thought the lowest standard, which the book's called adequacy, we also thought that level of evidence was inadequate. So we thought the highest level, probabilities, and the lowest level, adequacy, were inappropriate. And instead we settled for one which the book's called plausible levels of evidence, which is defined and described. So using that test, we then looked at these policies, which were explicitly human rights shaped, and we looked at what had happened in the country when we looked at the data. And it seemed to us that it was possible to make the argument that those human rights shaped interventions had contributed to the health gains. We did not say caused. I don't think it's possible to do that, but to say it had contributed to, along with a lot of other things that were happening in the countries in question. So all that stuff raises really difficult issues of methodology, of epistemology, of causation, which require much more work. But I think if we're interested in operationalization, that takes us into multidisciplinarity, and that, I think, takes us into this question of evidence of impact.
Okay, down here now. And then, well, we'll just take this one first, and then if we have time, we'll come up to the back over there. Yeah.
Thank you. I want to follow up on the questions about neoliberalism. Paul, you were very sort of made a blanket statement about how neoliberalism has kind of led to increasing inequalities and human suffering and so forth. But isn't, in a sense, you know, doesn't one have to look a bit further in that neoliberalism as a sort of a model of economic policy has contradictory effects to human well-being in certain areas, but not in all. And that the health sector, the organization of the health sector, is particularly one where there are these trade-offs can exist. I mean, I don't believe that there is a trade-off between economic growth and human rights. But there are certain specific areas where there may be a lot more tension than in others. And isn't because the health sector and the sort of the provision of services, the production of pharmaceutical products and all of this, the economics of those operations are so relevant for the human rights to health and other rights as well, that the tension between neoliberalism and human rights is particularly acute in this sector in a way that it might not be in others. That neoliberalism may actually be quite positive for human rights in other domains.
Yeah, I'll have to go back to my precise words. Perhaps I wasn't clear, but I should have been confining myself to the health. I think that there's an inconsistency between the right to the highest attainable standard of health and, as presently practiced, presently prevailing, the economic neoliberal orthodoxy. And I think now there's quite a lot of evidence to support that position. And hence my answer to the question from the gentleman wearing the red pullover. May I, Roger, please make a comment which is partly in response to Octavio's remarks. Is that okay?
Yeah, can I just check with John about, John, have we got time for one more? Yeah, it's okay, and then we'll take the question right at the back there.
I'll interrupt me if I go on too long, Roger. I'll try and be brief. Look, the issue of maximum available resources is really difficult. It requires much more intellectual work. I accept that. And I look to Sakiko, and she provides me in her work with some guidance, and Diane Elson, and so forth and so on, and much more needs to be done. You know, Albert Wheel was at a seminar on the right to health not long ago, and he used the phrase, don't ask what the right to health can do to you, ask what you can do for the right to health, right? And I was going to use that as the heading for my talk, but then I didn't in the end. But, you know, we need help from developmental economists to work this out. And I don't pretend for one second to have all the answers. I mean, no individual does. So, but can I make this point? Look, when rapporteur, I was invited to go to India to look to the right to health. Can you imagine? India, the right to health, in 10,000 words. So I was happy to go, and I looked at one particular issue, maternal mortality in India. And I chose to look at 2 states in India. That was still a huge undertaking. But myself and colleagues did the best we could with research and talking, many people as possible. We went to India, we traveled a lot, and so forth and so on, meeting ministers through to community groups. Look, one of the things that we found in India was that the government was very proud of a policy it had, which was the training of ANMs, auxiliary nurse midwives. And these were, it was understood that these were there to help women in childbirth, and they were there to ensure that maternal mortality was as low as possible. Okay, great. And there were 130, from memory, there were 130,000 ANMs in India. That was a lot, even for India. But when you looked at the ANMs, they had, 30 years ago, their training included a lot of stuff on midwifery. But over the years, they've been given more and more duties and more training, and the midwifery training had got smaller and smaller. And in the end, it struck me, and others, I wasn't alone, that actually these 130,000 ANMs did not have the competency to be midwives. It wasn't their fault, it was a matter of their training. So at first sight, it looked fantastic. India's doing a lot to address maternal mortality. You look more closely, and they'd made a mistake. And in my report, I argued that this constituted an inconsistency with with the government's international right to health obligations. They didn't argue that there was insufficient money. They'd made a mistake. And the right to health prism applied to the A&Ms helped expose that mistake. Now, other prisms could have done too, but they hadn't. In India, another problem was that when I asked in the federal level, health is devolved, but when I asked at the federal level, how many technical officers do you have dealing with maternal health? From memory, forgive me if I'm slightly wrong, from memory there were 3. Right, 3 for India. Sorry, this is not credible. And it wasn't that the government was saying we don't have enough money to appoint more technical officers. They just had made a mistake. They hadn't got enough technical expertise on maternal mortality at the federal level, which was meant to be monitoring what was happening throughout India. It was ridiculous. But it wasn't because there was a lack of resources. There was a mistake. Now, thirdly, and then I'll be quiet, Roger. Thirdly, when I asked, well, do you have a plan about reducing maternal mortality? And at that time, there wasn't one. And it struck me that those 3 things constituted violations of the government's obligations, violations of the government's responsibilities and obligations under the international right to health. No plan, completely insufficient technical officers at the federal level, and the A&Ms, no fault of theirs, no longer had the competencies to do the job that they were meant to be doing.
Well, thanks, Paul, for that very compelling example. I think perhaps just this last question we make, I don't know whether we've got 1 or 2 questions just on the back.
2 girls.
I know is it 1 question that you're sharing, or?
Yeah.
Yeah, okay, go on then.
Okay, hi. Me and my friend were year 13 students, and my question is for Mr. Hunt. When you were listing the 4 things that you think is hindering the right to health, you mentioned a consensus approach where everybody agrees. So we agree with you in thinking that that kind of approach can silence the voices of the people that actually need to be heard and the people that actually need the help. So our question to you is that do you think that this kind of approach is going to be changed? And if it isn't, do you think that this is like institutionally constructed to stop progress? So that's my question. That's our question to you.
Well, Octavio might want to respond to this as well, but at the moment, I think it's not settled how to figure out the content and scope of the right to health. I think it's disputed as to what the appropriate mechanisms should be. And in the books, some of them argue it should be a consensus approach. And I was putting a question mark over a consensus approach. So I think we're still trying to work out what would be a suitable process for determining the content of the right to health. And some favor consensualism, I don't. I'm sorry if I've missed your point. We can talk over lunch. Okay? Octavio, do you want to have a go?
No. Okay, well, look, thanks very much indeed to Paul and to Octavio for plenty of food for thought and some brilliant talks. Thanks for your questions, but it is time for lunch, and we will resume early this afternoon.
Thank you very much. Thanks, Roger. Thanks a lot.
Thank you.